Approach. Off the record. Approach. That's not what you asked. Go back now.
Mr. Reyes and what he's charged for, correct?
Objection, relevance.
I don't understand the question.
I don't understand it. I'm sorry. I'm trying
So the question is, the objection is sustained. Anything you do, anything he does, is not relevant to that investigation that day. Be more specific.
In the town clerk's office, in the afternoon, sir. Yes or no, if you can.
I'm just stating objection.
No.
That's the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
Talking this whole thing was very intriguing to me because until the library incident, I have never heard of First Amendment auditors.
The incident at the library that you're talking about in the videos, you're talking about the videos involving, I think it's Tippets and Utter, and the statement that if he'd done something 20 years ago, he would have been dead in the back of some
Objection
trunk.
is what?
20 years ago, that motherfucker would be dead. His teeth would be missing. I don't know.
I'd have removed his teeth. He would be dead.
This is not going to end well with you, you know that.
Okay, we'll see.
No,
will see.
I'm telling you.
I can see it in your eyes.
In law enforcement experience,
Yeah.
I'm still here.
After they released Reyes and he went outside, Officer Ken Utter taunted him.
Constitutionally protected activity. If I went in there and I was acting like an asshole,
You're wrong.
don't touch me. Don't touch me. Don't touch me. Hey.
20 years ago, that motherfucker would be dead. His teeth would be missing. I don't know.
I'd have removed his teeth. He would be dead.
I'm still here. I'm still here.
20 years ago, that motherfucker would be dead.
I'm still here.
His teeth would be missing.
I'm still here.
I'd have removed his teeth. He would be dead.
I'm still here. I'm still here.
All rise. Court's back in session.
Good afternoon, Your Honor. Good afternoon. Please be seated, everyone. Okay. So, we are back, State versus Reyes. I want to thank everyone. I'm hopeful that you got word yesterday that I just felt starting a little after 3 and going a little before 4 was not going to work. And that was the best we were going to do. So to have you come up in the weather and the risk of having to go home in weather was traveling not so bad. I didn't think that was fair to anybody. I know some of you come a long way. So with that being said, I'm glad you all got the information. So we were in very good shape today to start at 2:15, and there was a matter that was a very difficult matter of post-judgment that we had to take up. So with that being said, we are starting. I'm inclined to go. Do we have any objection to going to 4:45?
No. No.
We'll go to 4:45, and then tomorrow, the docket is very small, and there's no significant post-judgment matters that I have to deal with before we move on to this. So we'll start, and we should get the full 3 hours in tomorrow. And we'll see where we are at that point. I appreciate everybody's flexibility. We've been trying to get this done, and but certainly done where no one feels that they haven't gotten in or out what they want to say. So here we are. We have a witness ready to resume the stand.
We do, Your Honor.
And we have the video queued up to where we left off.
It is.
All right. And for the record, counsel, they're both here. Attorney Cooper is not here. Is he okay?
His daughter was sick, so he didn't make the trip from Brooklyn, and so but he promises he'll be here tomorrow because he misses the whole thing.
He misses me?
Yes.
Okay. So tomorrow. Good. I was concerned. I didn't see Attorney Cooper. I mean, there was an issue, but so we're going to pick up where we left off. The motion limine is out there and has been granted. So anything said by someone in this video that is not a party to the action or is not testifying in the court is hearsay unless there's an offer of proof as to why a statement is a non-hearsay statement or fits into one of the exceptions to the hearsay rule. With that being said, we can have our witness retake the statement. to remind you that you're still in the room.
To try to stop him from going up the stairs.
Oops, sorry.
How you doing?
Okay, and you? Statements. All these statements. Remember, the less said, the more better.
Not anymore. Not these days.
No,
It's a
less said, the
different-
better. Single declarative statements. No thoughts, or I thinks, or I thought.
Objective.
That's exactly. Dad was a cop.
I'm well aware, I know.
And he
He
corrected
was a
everybody.
chief, the deputy chief, right? Something.
No, he was a captain.
Captain, that's right. Close.
He would correct everybody's
Everybody's garbage.
and understand, like in other like, and throw it back at him, saying.
Yeah.
And it was the day of paper, so it was like, do it again.
Sheesh. Good old days.
Well, the old day, well, it was like, he knew it was going to get thrown out, so fix it first. Anyway, have a good day.
Thank you, you too. Let me see, it is what it is. I'll fill in the blanks. Fill in the best. Reyes circled around me and did not give me his name or accept the department card. As he headed up the stairwell, I thought in the best of City Hall, I keep my ground and prevent him from going upstairs. He kept coming toe-to-toe with me. I extended my arms to prevent him from going to the second floor. Okay.
Says what it is.
If you want to, yeah. All right, do me a favor, we're not done yet. Sit. Where's the pen? You got your pen?
Yeah.
Okay. Just put your initials in there.
And then sign block.
Anywhere you did these crossouts, just put your initials by the crossout, okay?
I'm gonna try to get white out.
No. Just put your initials. No, because then it looks doctored. You're not supposed to use whiteout.
What else?
I don't know. Did you cross out anywhere else?
Yeah, I
think
kind
that
of
was the
squeezed in
only
a couple
one.
of letters.
Yeah.
But did not. He did. I put did not. But he
That's fine.
did not here. Yeah.
That's fine.
I mean, I cut trees on my hand. I can barely hold it. My hands are so.
Sign, date, and time. Today's date is July 15th. The time is 11:32 a.m.
Today's 7, 15, 21, 11:32
a.m. So I'm going to. I'll just sign this one.
Come down here.
So, I'm going to submit a warrant. I'm going to review the camera footage, right?
Yeah.
I'm going to get his statement. I got his statement, your statement, and the camera footage.
Yeah.
I'm going to put that all in a report.
Yeah.
I'm going to review it.
Yeah.
If I have probable cause to believe that your actions
Yeah.
rose to the level of, I would call it an assault, since luckily he admitted to me that he was not injured and he did not want medical attention.
Yeah.
Although,
I'm injured. I mean,
although an
you got-
impairment of, injury,
Yeah.
according to definition, is impairment of physical condition. So I'm not going to do it to you.
Yeah, but I mean, I didn't.
But if
I just like
I know it
hands,
doesn't
that's-
matter. If you push somebody, I'm not going to do it to you because
Yeah.
I don't want to assault you.
Yeah.
But if you impaired
Yeah.
somebody's
Well, it was
physical
nothing like
condition,
that. I just kind of put my hands up.
well, okay. So, however, if I think it rose to the level of a discon,
Yeah.
I'll submit warrants, maybe even for both of you. If some of his language is to the point where it's
Yeah.
disruptive,
Yeah.
then I'll submit a warrant for both of you, and we'll see and then it's up to
So
the
you told
court.
me I could get arrested?
Yes, it's up to the court. You got physical with somebody that, for the most part, you really had no reason to be physical with.
I didn't want him going. I
Because he
wasn't
was
going to go
filming.
upstairs.
I know, but for
Yeah.
what? For what? He's filming. What is he doing? Why can't he go upstairs? It's a public building. It's City Hall, for Christ's
Yeah.
sake.
Like I said, if I was given those forms,
You know? That's the problem. It's a public place. These guys right now, they're allowed to be in here.
But me, like I said, it bothers me.
And
You guys gotta get out of here.
that's just a BS rule. That's not, it's not against the law to not fill that out and him what, you know what I mean?
But that's what I was told when I came here.
I know, well,
Sign on the door. Look at the sign on the door.
We stop it at the 108 mark for a moment. Sergeant, when you interviewed Mr. Genussa, without knowing what was said where, what information did you not have at the time you interviewed or took a statement from Mr. Genussa? I'm sorry.
yes,
Objection, Your Honor. What's the relevance of the information? I don't know how to respond to that, what he didn't have. We have the video here. I don't understand the question.
I assume it's preliminary. I'm going to allow it, and if it's not relevant, I will, if the answer turns out to be not a relevant line of questioning, I will not only sustain the objection, but strike it.
Understood. What information did you not have available to you at the time you took a statement from Mr. Genussa on that day of July 15, 2021?
yes. I did not have the entire video footage from Mr. Reyes, and I did not have any information regarding what the posting on the door was in regards to. So the guests must sign in, but I didn't have the knowledge at the time of what that was regarding, or why that existed.
And those things you said you did not have available to you at the time?
Well, I just didn't obtain that information yet.
At the time you spoke to
At
Mr.
the time I
Genussa?
spoke, yes, well, as we can see in the video, at that time, I did not obtain what that sign was about.
That's it.
Next question.
That's
More
it.
questions?
No, I'll continue with the video.
Judge, he's going to examine him. Do you want me to hold off on cross-examination when he stops the video, or?
When he concludes his direct examination, we begin your cross-examination.
Okay, no, I just.
Which, I'm sure you have. Right.
Yes, yes.
I understand what you want. It's odd that there's disjointed question, video question. This is the way we're trying to proceed. There's a mountain of video, probably more than I realized. I mean, this seemed like a good idea in terms of setting up this way. But under the circumstances, it's working fine. So counsel has his witness out to introduce the exhibit, and he's asking questions intermittently as the exhibit plays, as we do with the other witnesses. Certainly, you will have a full and unfettered opportunity to cross-examine this witness when the direct examination is done.
Thank you very much, Judge.
So hopefully, visitors must sign in.
Okay, I know.
All visitors must sign in. It's everywhere. So we're gonna have stickers soon. Anybody recording must fill out a form.
I know, well,
No.
I'm glad they did that so quickly since the last incident. Hopefully these guys go to bat for you too, in that they told you that you're supposed to stop anybody.
Don't. No, okay, Sarah. I'm sorry.
You know, and not for nothing. Whatever, it is what it is. It's not against the law. Like this woman right here, walk around this counter, start filming, and go upstairs.
Yeah.
It's not against the law.
Yeah.
You can't block them and by blocking the stairs and being physical and stopping him. That's where the issue is.
These two guys came in the other day.
I'm not siding with him. I'm just telling you what the facts are, how this works.
So these two fellas came in. Last
Let's
week.
go outside.
Yeah, they came in last week. One guy, they gave him the card. One guy's last name, he went by Lee Lawson. They gave me their name, they took the card, they were polite, they would have not.
Go again, 88.
Asshole. And they said, we want to go ask.
There's a name in the queue for you when you have a chance.
Roger.
They said they wanted to go up to the town clerk to ask them questions about the bell and history of that. I said, that's fine. But they were polite, they gave me their name. I sent them on their way.
But it's not against.
Like I said, this guy just.
I gotta go. I got a lot more stuff to go on. I don't mean to cut you short. I apologize, but I got a lot more to do.
At this point, Officer Iacobellis returns to the Danbury Police Department to take my written statement against Phil Genussa. Iacobellis and I have a 2-hour conversation that was played in court, most of which is completely irrelevant to this case. I did inform Iacobellis that I had to return to City Hall to prove my point, not to engage with Phil, and he jokingly told me not to go back, then told me that I did have the legal right to do so. In the spirit of full transparency, our full unedited conversation will be linked in the description of this video.
Reyes at the Danbury Police Department. When you went into the room to speak to him, your body cam was on. How would you describe the atmosphere in that room? From your point of view.
Positive. We had a good conversation.
And how would you describe his demeanor? Did you notice any changes? Was it the same?
Yes,
When you saw back at the-
absolutely. He even alluded to it in the video. When he wasn't on his cell phone camera, he was far more personable, as is evident by the.
And do you recall him using the word deadpan when he's filming at City Hall?
Yes.
From your perspective, did he appear to be much different to you when you were speaking to him one-on-one at the Danbury Police?
Objection.
Yes.
What is the officer's opinion on whether or not?
Are you saying this is a question of relevance?
Yes.
Mr. Stain, I've seen the video. Enjoy.
Did you have any further interaction with Mr. Reyes later on that day of July 15, 2021?
That day, no, I did not.
May I just have a moment, please, Your Honor? Yes. Just need a few moments, Your Honor. I have no further question.
Well, good afternoon, Sergeant Iacobellis.
Choose your one. Tracy, you can proceed.
Yes. Good afternoon, Sergeant Iacobellis.
Good afternoon.
I'm going to just draw your attention back to July 15, 2021. And you were called to Danbury Police Department on that day, Danbury City Hall that day, correct?
Correct.
And do you recall what the purpose of your visit there was?
It was a disturbance call, I believe.
Okay. And when you arrived, you had a conversation with Mr. Reyes, didn't you?
Yes, I did.
Okay. And at that time, were you personally able to observe any disturbance that Mr. Reyes was involved in?
He showed me approximately 3 or 4 minutes.
So, not your personal observation, but he showed you some video, correct?
Yes.
And he showed you some video, is that in the context of a complaint he was making against somebody?
Yes.
Who was that person?
Phil Genussa.
And sir, you know Phil Genussa, right? Before the incident?
Just in passing.
Did you know him from the hospital?
I didn't know him, I knew him in passing. We never really had a full conversation. We typically, security, especially up in the hospital, we see them quite a bit because we're in the emergency room quite a bit for work-related incidents. So.
You knew him enough to tell Mr. Reyes he's a pretty good guy, right?
Yes, because he was decent.
And you knew enough about Mr. Genussa to know that he worked at the hospital,
Yes.
and you knew enough to tell him, hey, there's a big difference between responding to somebody at the hospital and stopping somebody in the stairway because he's filming at City Hall.
That was in the context of their two different arenas, two different kinds of places.
All right, and so sticking to the arena of the City Hall and the circumstances under City Hall that are in place in City Hall, you also had a conversation with Mr. Reyes in the police department. We just saw 3.5 hours of video on that.
Yes.
And you asked the question to Mr. Reyes, well, what's going to happen with Phil now, right?
I believe so. That
Yeah.
sounds familiar, I think.
You were concerned with the report that Mr. Reyes was making, that it might affect Phil negatively, correct?
Objection relevance.
I'll allow it as something that's preliminary, I assume to align with the cross.
It's preliminary, he's setting the stage for the knowledge of Mr. Genussa.
Objections overruled, you can answer the question.
I'm sorry, can you ask?
Yeah, you recall asking Mr. Reyes, using words to the effect, come on, man, now what's going to happen to Phil?
I believe so, yeah.
So you're concerned about the effect that Mr. Reyes' complaint might have on Phil, correct?
Sure, that's fair to say.
Right. Okay. And in that conversation, let me go back to the time that you've seen the video, and the time, draw your attention to the video when you are asking.
Well, short portion.
Well, did you see the 3.5 hours of video here?
Well, there's so many videos. I
Yeah,
don't know which one.
I'm not talking about that one. I'm talking about the one where.
I'm sorry, I thought they said
Okay.
earlier line of questioning.
I think his response, he thought you might have meant the video he saw.
Yeah,
Mr. Reyes
my
showing
apologies.
on that day.
Oh, no, I'm not.
Ask your question again, make sure he knows what video, because Lord knows there's some video.
Yeah. So when you go in to interview Phil Genussa on the 15th of January, you go into his little office space there, right? In the front of City Hall, in the lobby?
It's not his office.
Mail room?
The office, yes. The
Mail room. Okay. And he's giving a statement at that time, right?
Yes.
And do you coach him in his statement at all, sir?
Objection relevance.
Overruled.
I help him. I help him the same as we help anybody with statements.
You help everybody with statements?
Oh, yes.
Okay. But you're not coaching him, right?
It depends how you define coaching compared to helping. There's times when we write statements for people, we question them and ask them questions because their writing abilities will write it for them. I'm sure you're familiar with that.
That wasn't the case here with Mr. Genussa.
No, he wrote it, but I helped him with it.
And so your characterization is that you helped him, even though you knew him from before, right?
I don't know, knowing him from before, I helped him with his statement, yes I did.
Okay. And did you put any words in his mouth?
I'd like to think not. I like to coach people through because I've done this, as I even said to Mr. Reyes, I've done this more times than they have.
Right, so you like to coach people through.
Objection
I like to help people through.
Argumentative.
Sustained. It's not what.
Sir, you recall your testimony about 30 seconds ago where you stated you like to coach people through it. Do you recall that testimony? That's the question.
That's what he likes to help people.
Judge, may I just, it's not his testimony. He
Call
used
it
the word
coaching
coach.
then, call it what you will.
Oh.
I helped him, I coach, I help every, like I said before.
And that's already been answered.
That's fine.
Keep going.
Okay. And sir, the nature of the complaint, that revolved around some interaction that occurred between Mr. Genussa and Mr. Reyes in the stairwell of the Danbury City Hall, correct?
Yes.
And do you know what the issue was there?
Objection goes to hearsay.
Overruled.
Do you know what the issue was?
Do I know what the
Yes.
issue was? That Mr. Reyes was trying to go past Mr. Genussa and Mr. Genussa stopped him from proceeding up the staircase.
And is that all you know about the incident?
I mean, there's more I don't know exactly what the question, how much you'd like me to elaborate.
Well, let me just do it this way. There came a point in the time where you're talking to Phil about his statement, where you tell him to make sure you put in his statement that he was waiting for forms from his bosses, right?
I believe so. It sounds
And was that your understanding that he's waiting for forms that Mr. Reyes was supposed to fill out?
Objection calls for hearsay relevance.
Overrule the objection.
I'm sorry. Your understanding, that was Mr. Genussa was waiting for forms at the time that he encountered Mr. Reyes in the stairwell, correct?
yes.
And those forms didn't exist, did they?
Objection. Look at foundation. How do you know that?
Sustained.
To your knowledge, you had we'll withdraw that. You spoke about forms to Mr. Reyes when you're talking to him about a statement, correct?
I spoke about forms when I was talking to Mr. Reyes.
Okay.
I believe so.
Right. And you wouldn't tell Mr. Reyes to write in his statement anything about non-existent forms, would you?
Objection. Argument and relevance.
Sustained.
Well, Mr. Reyes clearly didn't need.
Sorry.
Oh,
Question's been sustained. The objection's been sustained to the question. Attorney Seeker's going to ask you a new question or rephrase his previous.
Were you shown any of the forms that Mr. Reyes was supposed to be completing by Mr. Genussa on the 15th of July, 2021?
the only thing I had observed was the placard on the front window that all guests have to sign in.
Sergeant, I'm doing this probably earlier than I did the other witnesses, but his specific question was essentially calling for a yes and no answer. Your answer's going in a different direction. Do the best you can.
Sure.
Answer his question. If there's an objection, I'll field the objection.
Okay. I'm sorry.
Mr. Genussa didn't show you the forms that were at issue, correct?
No.
Okay, and did you investigate where these forms were?
Those particular forms, no.
Why?
Because a far more serious piece of this came to light shortly after.
Okay.
So when I got to that point in the investigation, I didn't see the relevance of the forms to film.
Okay.
I was...
So you made a determination that the relevance of the forms.
in light of the COVID requirements.
Right. Sir, didn't you, in your words, tell Mr. Genussa in his office, hey, next time just call us. If you don't have the forms, that's even all the more reason. It's not on you, it's on your bosses because you don't have them. Isn't that what you told him?
That was before I knew about the COVID.
I'm just asking if those were your words.
Yes, those were, yes.
So at the time you're using those words, you're saying, why would you do that for non-existent forms? Isn't that what you were getting at?
Essentially, yes.
Relevance.
Overrule.
And again, you coached them or helped them
Objection.
with the statement.
Ask the answer.
Sustained.
Now, in City Hall, I think your testimony was a far more serious matter arose, or some aspect of that matter arose.
Yes.
When you first came to City Hall, on your body cam, there's a point at the beginning where you start talking to Mr. Genussa about a promotion, right?
I'm not, if you took note of it, probably, I can't remember the exact point.
Fair enough. Didn't you tell Mr. Reyes in so many words, I don't need this, I'm up for a promotion?
I wouldn't say in so many words, but along those lines, yes.
Okay, and what about your involvement in this incident were you concerned about pertaining to a promotion?
Well, I'll tell you exactly. After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me. That's exactly that.
Right, that didn't happen to you, right?
Oh, no, it did.
It did?
Yep.
Okay. And the incident at the library that you're talking about, the videos, you're talking about the videos involving, I think it's Tippets and Utter, and the statement that if he'd done something 20 years ago, he would have been dead in the back of some
Objection is what?
20 years ago, that motherfucker would be dead. Easy fucking his teeth if he missed. I don't fucking do it.
I'd have removed his teeth. He would be dead.
This is not going to end well with you, you know that.
Okay, we'll see.
No, I'm telling you.
I can see it in your eyes.
In law enforcement experience,
I'm still here.
After they released Reyes and he went outside, Officer Ken Utter taunted him.
Constitutionally protected activity. If I went in there and I was acting like an asshole,
You're wrong.
Don't touch me. Don't touch me. Don't touch me. Hey.
20 years ago, that motherfucker would be dead. He'd be fucking, his teeth would be missing. I don't fucking do it.
I'd have removed his teeth. He would be dead.
I'm still here. I'm still here.
20 years ago, that motherfucker would be dead.
I'm still here.
He'd be fucking, his teeth would be missing.
I'm still here.
I don't fucking do it.
I'd have removed his teeth. He would be dead.
I'm still here. I'm still here.
You heard him say objection, right?
I didn't.
Okay.
Sorry, but yes, I did not.
No objection.
Yes.
Relevance, hearsay, outside the scope of duress.
Sustain, sustain, sustain. Keep going.
Okay. The incident at the library, were you familiar with what happened there?
Objection, same, all three grounds.
He brought it up, Judge.
There's been some discussion in the trial thus far about the incident that I'm going to ask this question.
And that involved Danbury Police Department police officers, right?
The incident, I'm sorry.
At the library, sir.
Yes, it did.
And you're familiar with the library incident, right?
Yes.
And are you familiar that Mr. Reyes made a complaint about Danbury police officers in that case?
Objection, relevance.
I'm going to allow it as...
At the time of this,
Okay, here's how it's going to work. He's going to ask you a question.
okay.
He may object. I will rule the objection. You don't answer until I rule the objection.
Got it.
It's just going to be easier for everybody. And that's partially on me because I talk. So let's try that again. Ask the question again, Attorney Steve.
So the videos that you were talking about having been posted by Mr. Reyes on the library incident, they detailed some pretty serious allegations against the Danbury Police Department, right?
Objection, form of question, relevance.
I'm going to sustain that objection.
Yeah,
We know there's
I
much to
understand.
talk about. We're not talking about that as it is.
I'm going to move along, I'm going to be fast, but I just want to preserve my record. He's talked about some pretty serious...
Sustain.
Okay, thanks, son. So you weren't at the library when Mr. Reyes was encountered by police on June 9th or 10th, somewhere there?
No objection.
Susan, I don't necessarily hear you all the time, so was
Same
that objection, quote unquote, same objection?
Yes, relevance, outside the scope of duress. Hearsay.
Re-ask the question.
You said you were familiar with the library incident, but you weren't at the library to observe anything personally.
I was not.
The objection's overruled.
Okay. Okay.
We're all very excited here to do what we're doing, but let's do it slow.
So I think we were on the promotion. I asked a couple questions about promotions before. Isn't it true that you didn't want to get involved in the case as you saw it from the beginning when you arrived on the scene because you thought it was petty?
No, that's not what I said. I tried to appeal to his sympathies because I was concerned. Because after watching some videos on his YouTube channel, I noticed that all of them casted the police in a negative light. So I was fearful that no matter what I did, I would too be cast in a negative light. And also, what I didn't end up saying was the multitude of threats that were received. I didn't want that, fortunately for me, I've never received any, but I didn't want that for myself and my family.
Fair enough.
Because there were people who were arrested for making threats against us. No, I'm just saying.
So
that
let's just move to strike the balance.
He's answering your question.
Okay, fair enough. But you weren't threatened, sir, were you?
At what point?
At any point?
I was. I received a couple on my work voicemail, but I just deleted. I didn't.
Did you put that in the police report somewhere?
Well, I was threatened after the fact.
Well, threats are important, aren't they?
It depends if you feel threatened or not, and I didn't feel threatened by them. I just deleted them. They were on my work voicemail.
So you didn't feel threatened about what people had said, correct?
Objection, pass the news.
I'll allow him to answer this question. Objection overruled.
It's a tough thing. I can threaten you right now. It depends. It all depends how you feel about it. I would hope that you wouldn't feel threatened by me, but so at the time I just deleted those messages. I don't remember if I felt threatened or not, but I didn't want to. I just deleted it. It was only a couple. It wasn't like the other people.
And again, in terms of threats, you never received any threats from Mr. Reyes, though, correct?
I never received those?
Yes.
No.
So you're talking about what you viewed outside of the evidence in the courtroom here. in terms of where you're getting the information, correct?
Well, not necessarily, not the threatening parts. That I learned from just that we arrested somebody. The police department arrested somebody for raping her.
But that person wasn't Mr. Reyes.
No.
And then, in fact, you have a conversation lasts a couple hours with Mr. Reyes on the video, correct?
Yes.
On the body cam?
Yes.
There's no threats during that time.
No, there's not.
And your earlier concern, I think, was that you didn't want to be painted in a bad light, like you opinion about other officers having been detailed on his YouTube channel, correct?
Objection has to be exploded.
It has been asked and answered. I assume this is the introductory question to an next line of inquiry, so I will allow.
I'm sorry, again, sir.
Yeah, when you're, before, what you're talking about in terms of being portrayed in a bad light,
Yes.
and you not wanting to be portrayed in a bad light,
Yes.
you're referring to YouTube videos that you've seen in the
Yes.
past
Yes.
that sort of bring
Yes.
police officers into a bad light.
Yes.
Well, but in your 2 hours of discussions with Mr. Reyes, you learned that he doesn't only do that, right? He doesn't only portray police officers in a bad light, right?
Objection, relevance.
I'm not entirely sure what you
Okay.
mean, sir. I'm sorry.
Sergeant, there's a question, there's an objection.
Oh, I'm just trying to answer.
Attorney Senator, perhaps if you stand and
I'm
speak
gonna-
up with
am I-
regard to making
I'm
an
sorry,
objection,
sorry.
it'll help Sergeant Iacobellis know there's an objection.
Here's my
The
objection.
objection is it's irrelevant line of question.
Correct.
I'm sustaining the objection.
Didn't Mr. Reyes tell you, sir, that he would portray you in a good light because you were a good cop and handled the situation well?
He did, yes.
He did. And did he go through any other incidents? Did you have any other discussions about when cops do good things, he puts that on his YouTube channel too? If you can recall.
I don't believe he said he puts it on his YouTube channel. I think at the very end there, we saw that he said something to the effect that we should try and lift up the good old.
Fair enough.
But that's not what's on that channel.
And in the conversations you had with Mr. Reyes, there was a lot of extraneous stuff like going out to lunch, having beer. Was it space
I
cops
don't
or
think we
space?
mentioned beer.
You don't think you mentioned
There
beer?
was a lot of extraneous conversation because, and I knew this question, so to try and phrase it the best way I can. So Mr. Reyes was very respectful. He was willing to communicate with me, and he was reasonable. But he had very different viewpoint. And typically in life, those are the kind of people that you're going to learn the most from and that are the most interesting. Someone with a different viewpoint than you, who's also reasonable and willing to communicate with you. You don't get that every day.
Fair enough. So it's a learning experience by a nice guy.
Yeah, I suppose so. Yeah, it was just he made it for good conversation. And I
Right.
was happy to.
So you don't recall saying to Mr. Reyes, hey, let me go take the dogs out, let's go to dinner, you can have a beer?
I think lunch. I don't think we said beer. I think let's go to lunch.
Fair enough.
I think we mentioned beer. We might have mentioned drinks. I'm not sure.
Drinks, okay.
No, I don't think beer.
And you weren't doing that to butter Mr. Reyes up.
No, I was interested in talking to him.
There's an objection, Judge, I heard this one.
I'm gonna withdraw the objection.
I heard objection.
That was gonna be
It's withdrawn.
The question's already been answered.
No, as you can see by the video, we had, there was quite a long diatribe, and most of it wasn't even interested in talking. This whole thing was very intriguing to me, because in total violence, and I have never heard of First Amendment auditors. So the whole thing,
Fair enough.
I had it off. You can see it in the video.
Okay. But you weren't inviting him to lunch and drinks or a beer, let's say, because you wanted them to let the case go or anything like that, right?
No, as you can see, I had full intent in investigating it. I told him what the steps were, and that's indeed what I did.
And I think you told Mr. Reyes that you were going to submit a warrant in this case, correct?
Yes.
Did you do that?
Yes, I did.
And who was the warrant, which arrest was the warrant in support of? Was that for Mr. Reyes?
I submitted a warrant for Mr. Reyes' arrest, yes.
How long after July 21st did that, July 21st, how long after did that happen? I'm sorry, officer, one second, let me just check my notes from the day. The date of the incident in this case is, I believe, July 15th.
Yes.
How long after July 15th did you do that?
Well, I investigated the case. I had found out information the next day, and to be honest, I can't even recall. I have all that information's in-house. I have access to it, but I can't even tell you honestly.
Fair enough.
When after I wrote.
You said you had the luxury of time to Mr. Reyes when you were in the
Yes.
lobby to the Audit.
Yes.
And did you have, you had the luxury of time to investigate what happened, correct?
Yes.
Okay. And when you investigated it, you submitted a warrant, not for Phil,
Correct.
but for Mr. Reyes, correct?
Correct.
But it was Phil Genussa who was the person who was originally complaining about, correct?
Phil Genussa was originally complaining about, yes.
All right. And in terms of the conduct that occurred in the stairwell, your words to Mr. Reyes was, hey, I don't agree with what he did.
Yeah.
Correct?
Correct.
Phil was wrong.
I don't agree with
Relevance.
Did you say that?
Objection, relevance.
So that's sustained, that's not relevant. And I think the line of questioning, the warrant, Mr. Reyes, was for the fatality, it wasn't just for the incident in the stairwell, right? You're juxtaposing his conduct on the stairwell with Mr. Genussa's conduct in the stairwell. That's what you're doing?
Well, something like that, but I know that we're here for this particular instance about the trespass and focusing, trying to focus on
7/15/21 in total.
Correct.
Okay.
Yeah. So when you talk about other police reports or other investigation, that wasn't in relation to the occurrences of July 15th, 2021 that involved Mr. Reyes in the clerk's office, right?
I'm sorry, that was confusing.
So-
You could just,
Sure. You said that the warrant that you did was after, and you had some time and you did some investigation, correct?
yes,
But earlier you did say that you submitted a warrant for Mr. Reyes, correct?
correct.
And the warrant that you're talking about, is that different from one that you prepared for somebody else after the 21st of July?
Relevance. Objection, relevance.
Approach. Off the record, approach. That's not what you asked. Go back one.
Sir, as you sit here,
So the question, the objection to that question is sustained. You can ask, rephrase the
So-
question.
we're here for Mr. Reyes in relation to July 21st, correct?
Objection, relevance.
July 15th.
I'm sorry, you're right, you're right. It's July 15th. I don't know
correct.
why I have the 21st in there.
Neither do I.
Well, I did that earlier in the
Yeah.
beginning, remember I got June and
Well,
July.
see, two
so-
Ps.
It happens, what do you
Yeah.
do?
Great minds
Someone
think.
ask a question.
Thank you. So we're here for that date, July 15th, 2021, right?
Yes,
And when you say there was another investigation or a further investigation, that didn't involve Mr. Reyes and the conduct that's alleged to constitute criminality on the 15th of July, 2021, right?
so when I say there was further investigation, so I'll just give a little diatribe here so that we
I would object because it's non-responsive to the question.
Ask the question again. You listen to the question. Objection is sustained. What is your question?
The only warrant you prepared was for Mr. Reyes, correct?
Correct.
And that warrant pertained to conduct on the 15th of July, correct?
The morning of the 15th of July.
The morning of the 15th of July, not beyond the 15th of July.
Correct. My incident that we saw on body camera, that's my incident. That's-
Right. So anything that you do after the 15th of July has nothing to do with Mr. Reyes and what he's charged for, correct?
Objection, relevance.
I don't understand the question.
I don't understand it. I'm sorry. I'm trying
The
to.
question is, the objection is sustained. Anything you do, anything he does is not relevant to that investigation that day. Be more specific.
Did any investigation that you undertook
With regard to
after July
Mr. Reyes?
15th pertaining to Mr. Reyes, was there any such investigation?
Any investigation that I partook
Correct.
after July 15th.
Correct.
Well, so I'll just give a little diatribe. Please.
I'm gonna object to the form of the question. I don't understand it.
It's a yes or no.
I don't understand it. Are you asking him if besides his investigation into this incident on July 15th, were there any other investigations into Mr. Reyes? Is that what you're asking?
Correct.
Can you answer that question?
Was
Besides the investigation for the conduct that day that we've all seen,
yes.
besides that incident,
Mhm.
did you undertake any other investigations regarding Mr. Reyes being the subject matter of the investigation?
No.
There's your answer, Tracy.
So you didn't learn anything further about Mr. Reyes and his conduct on July 15th from a subsequent investigation, correct?
I may have learned that he was arrested later that day, but it has nothing to do with this investigation.
Okay, and that's where I'm going. When Mr. Reyes was arrested, you weren't the arresting officer, right?
No.
And when Mr. Reyes was arrested in the town clerk's office on the 15th of July 2021, you didn't see any of it, correct?
Correct. I was there that day, but I was in a different part of the, I was on a different.
And so you have no personal knowledge of what occurred, correct?
The specifics of it, no.
And nonetheless, you prepare a warrant based on that conduct to have Mr. Reyes arrested? Is that what you did?
I'm going to object because that mischaracterizes the testimony. He said he
It's a
had it
question.
in the morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question, Tracy.
Sir,
Yes.
you weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection, ask the answer.
Sustained.
Okay.
We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15th, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can?
Statement objection.
Nope.
Ask the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Course now in recess.
Tracy Seeger, your witness.
Yes, Your Honor. Okay, officer, before the, sorry, Sergeant. Before the break, I was inquiring about the warrant that you did in this case, correct?
Yes, sir.
Okay, now I'm just specifically asking you, did that warrant that you did pertain to conduct that happened on the 15th of July in the afternoon at the town hall?
No.
Well, what did it pertain to?
The incident that was outlined in my body camera, for lack of a better term. The morning.
Okay, so your testimony is that the warrant that you worked on pertained to conduct that stopped before the afternoon of July 15th, 2021?
The conduct would have stopped. The incident that occurred that we were speaking about.
Okay, well, fair enough. In other words,
it's a separate CFS. It's a
Okay.
different case.
separate CFS.
Separate case number. Yeah.
Separate thing. Okay. And this thing here, why we're here today, pertains to a trespass infraction and a creating public disturbance infraction. You didn't do any warrant or investigate that, did you?
I'm sorry, I didn't hear the, I'm sorry, no objection, I didn't hear the question.
You didn't investigate that on the 15th of July, 2021, right?
Ask the answer, objection.
Okay. We just went through this 5 seconds ago, 30 feet away. The first question was, you had nothing in, the warrant you submitted was for the incident on the stairwell when you were there in the AM, before he went back to the, before he went back to the.
Before he went back.
So now the question is, your investigation did not pertain to the arrest which took place later that afternoon when he returned to town.
No, I have zero, I have zero to do, or zero investigation with the afternoon's incident. That was
Okay.
Officer Contreras, Officer Farrell.
So you can't testify about anything factual that happened on the 15th of July, 2021 from your own personal observations of Mr. Reyes, correct?
The afternoon?
Yes.
Only what's been shown in court, that we all, you know, only what I've seen
Fair enough.
from his videos and the body cam that we've seen here.
But again, from your personal observation on that
From my
day,
personal
nothing, right?
observation, no.
You don't even know what happened, correct?
Well, I know
From
what
your own
happened.
person, just a bit.
There's an objection.
Actually, I'll withdraw, Judge. Think
Sorry,
fast.
I'm not-
I'm gonna see if I can wrap up. I'll withdraw.
Okay.
I'm sorry, I gotta pay attention.
You know, Sergeant, you're trying to do a professional job in cross-examination.
Mr. Pinter, do you know who he is?
Les Pinto, yes,
Yeah.
he's the corporate counsel.
In the course of your investigation pertaining to Mr. Reyes, the morning of, did you have occasion to speak with Mr. Pinter?
No.
And what about the town clerk? I think it's Jan Geiger.
No.
You didn't speak, I don't know.
No.
Okay. Based on the videos that you saw, actually, first of all, when did you see the videos of the incident that we're here for? If you can recall.
Which ones, sir?
Any of them.
And,
Well, I'll narrow the focus. Did you see a video of interaction between Mr. Reyes and the clerk and Mr. Genussa?
Mr. Reyes, clerk, and Mr. Genussa. I think sometime after I had watched a couple more of his videos pertaining to Danbury, I don't know.
Okay. And, sir, when you went into City Hall on July 15, 2021, in the morning, did you happen to see Exhibit 5, this policy? Actually, it should show me the actual exhibit.
And I don't think that's the actual exhibit.
Yeah, he's going to get the actual.
I'm going to get that. It's not my signal.
I just want the record to be perfected and portrayed accurately.
See that policy on the door at all?
There were a lot of postings on the door. I remember seeing something, all visitors must sign in.
Right.
It was a while ago. I can't,
If you don't recall, you don't recall.
If you don't recall,
It
you
was a
don't.
lot of reading, no. I
Did
don't
you-
recall if
Is there a separate quick question? You don't recall from reviewing your body camera that this was on the door either, correct?
I have to, I mean, we could look.
Fair enough.
I can't.
No, we don't want to do that. We just see if you can remember it. And then, same thing with respect to Exhibit 2. If you can recall, you recall that being on the door anywhere?
Thought it was something that was,
Like a
letters, just all visitors sign in.
Okay. And it's just same thing with respect to the body cam that you reviewed, you recall this being on the door by way of you reviewing your body camera? That's Exhibit 2 for the record?
I didn't really review, I went through it.
It's okay if
Fair
you
enough.
just know.
No.
It's okay? Yeah. Mix mine up. And one moment, just take a quick look, Judge, I may be able to wrap up.
So see here this.
No further questions, Judge?
So is that?
Did he finish?
He said no further questions.
Is there a reason you told Mr. Reyes not to go back to City Hall? I think it's on the video. Why did you tell him that? Not to go back to City Hall?
Just because I thought it.
Objection, Your Honor. This goes beyond the scope of my cross-examination. I didn't delve into this officer telling anybody to go back to City Hall. It was beyond the scope of my cross-examination.
It's part and parcel. He asked about the whole interview with the guy, with the defendant.
There was discussion in the interview and discussion, maybe he likes to coach witnesses. I will allow a question.
Is there a reason why did you tell Mr. Reyes not to return to City Hall?
Objection, Tom. What's the relevance of it?
I assume it's preliminary. I will give you some latitude.
There's some question about you when you were speaking to Mr. Genussa about the importance of coaching. Is there a reason why you told Mr. Reyes not to return to City Hall?
Objection, Your Honor.
Overruled. Answer the question, Keith.
Because I didn't think I knew could, but typically, if there's already been an incident between two people, it's in my interest to try and, if I can, tell those two people to stay away from each other. That's just, that's what every police officer does in that. You know, I've told people in similar cases in domestics, look, you can stay here, but it's not a good idea if you do stay here. I'm just trying to, and I said it jokingly, knowing that it's not going to go back.
That'd be good. One moment. Thank you. I let
Again, sorry. On the subject matter of going back to the city of Danbury that you were just asked questions about by the state's attorney, okay? Didn't you also tell him that it was legal for him to do that, sir?
Yeah, of course it's legal for him to go back.
Those are your exact words.
Yes.
Even if I don't want you to go there, it's within your legal rights to do so. It's legal. That was your words, right?
Yeah.
No further questions, Judge.
Is that?
nothing further.
Sergeant, you said
I don't know.
Do you have any further witnesses?
This time you're on the state rest.
State rest. Here is 407.
Yes, sir.
Do you intend to call any witnesses? And if so, I'll make the necessary candidates.
Just for the purposes of the record, I'd like to file a motion for judgment of acquittal. Hand that up to Your Honor, and I'll also give it to the clerk.
You just give it to him.
I have especially short arms.
Sorry. Give it to me, I'll hand it to him.
No, I did not receive, the state did not receive the promotion.
I received it 14 seconds ago.
Okay, thank you. It's rather voluminous. I would take the state would have for some time to review it.
So what I'm intending to do here in that, it is not usual. Oftentimes, in cases, there's an oral motion for judgment of acquittal made at the close of the state's case. And sometimes they're denied, sometimes they're granted, and oftentimes action on them is deferred until the end of the defense case, if in fact the defense is going to present a case, and then it goes right to deliberation, potentially. This is a court trial, obviously not a jury trial. The law with regard to motions of judgment of acquittal usually involves a jury trial, right, when the jury can reasonably find X. I have the motion here. This is obviously a written motion, researched with citations and attached case law. It is 18 pages in length. So what I would like to do is defer, continue to see if the defense is putting on a case, and then certainly I will render a decision on this upon looking at the 18 pages, and then we will proceed to closing argument if in fact the case was still pending at that point.
Yeah, just one moment, Judge.
Yeah.
Judge, Attorney Goodwin just pointed something technical low. It is it's named judgment of acquittal. Also, there's some requests for a motion to dismiss in there because the charges against him, and the statute says apply to this concept. I'm just
All I see is a document 18 pages
Yeah.
length that you presented to the court for the first time, about 406, titled Motion for Judgment of Acquittal. It's not titled Motion for to Dismiss.
Well,
So
that's
you
fine.
kind of gradually work up to a motion to dismiss within the motion for judgment of acquittal?
No, I think that the motion is appropriately filed at this point, because I have to wait for the close of the case. But I'm just drawing the court's attention.
I'm asking you, if somewhere in these 18 pages it becomes a motion motion to dismiss versus a motion for judgment of acquittal,
Yes,
you would agree that those are two different things.
Yes, that's why I'm pointing it out.
So I would defer judgment on that too.
Thank you.
Does the defense intend to call any witnesses?
No, Your Honor.
Okay. I will canvass anyway. Certainly, Mr. Reyes, you are the defendant in this case. In a jury trial, I would tell you if in fact you decided to testify or you decided not to testify, there would be instructions given to the jury explaining to them that no prejudice is to be placed upon you if you don't testify, and certainly if you do testify, that should assess your credibility as they would assessing credibility of other witnesses. Right? So that's kind of the usual canvas that's made. You have the right to testify. You're the only one who can make the final decision whether you want to testify or not. Counsel has just indicated to the court that he doesn't intend to call any witnesses, so I'm going to assume that means you have made the decision to not testify yourself in this matter.
No, Your Honor, I will not testify. I stand on the video evidence.
Right, so you're not going to be testifying
I will
here?
not be testifying here.
Thank you, sir.
Thank you, Your
Thank
Honor.
you.
So it is now 4:11. Here is my suggestion. I will take the rest of the day, look at the 18-page document here. On Monday, we will have, I will make rulings on this preliminarily to any closing argument, and if there's still a case that there's going to be closing argument for, we'll go right to closing argument at that time. And then, depending on the length of the closing argument and where we are in the day, I will begin to deliberate, if I can, the same day. Certainly, sometimes in situations like this, deliberation takes place over the course of downtime, amongst other things, and they're called back when there's a verdict, but certainly under the circumstances here, I will try to be as expeditious and efficient as possible. Okay? So that's generally the plan. Does the 2 o'clock still work? Because I still have a docket I do in the morning.
The counsel I approach this on a matter very briefly, Your Honor?
Yeah, and as an aside, when we have the sidebars, those are not for, because I'm sure you have microphones here far better than we have in the state system. So just so when you're going through, gentlemen, the sidebars when we're off the record, that means we're off the record. It's understood?
Yeah.
Okay. So we're off the record now.
Look at this crap and watch the play.
That's what he's doing.
All right. Please be seated. Okay, so we spoke in chambers just for scheduling purposes. So the way, if in fact closing arguments become something that are going to take place, we're going to take place Monday. We're going to take place, we'll do 2:15 again. I will render a decision with regard to the motion for judgment of acquittal, which also apparently speaks to issues regarding requests and motion to dismiss. I will look at that. Like I said, I just received it today. If in fact the case survives that, we'll proceed to closing argument. You understand, all the counsel here are experienced. The state will get 1 hour, which they can split into 2 arguments, and those arguments are sandwiched around Attorney Seeger and Attorney Krupman's argument, which they would have 1 hour as well. Certainly there's no one to stop you from taking less time, but I will not be giving you any more time. So each party will have a total of 1 hour to sum up whatever positions they have with regard to a closing argument in the case. At that point, depending on what time it is, I will go into deliberation, but certainly under the circumstances here, I would suspect that there's enough information here that it may wind up being certainly either a written decision or more of a prepared decision that would read onto the record at a future time. I'm told that we have a potential conflict coming up after that, so certainly I wanted to get at least that part of it done. So on the 30th, we'll finish, and then we'll talk about a date when we'll come back in if and when there's a verdict. Okay, does that seem fair? That accommodates people's schedules. It allows us to finish with the exception of obviously the important aspect of the deliberation, right? As you know, there's no jury here, so it would be me. And with regard to the way I'm going to go about the deliberation, the disorderly conduct, 53A 182, the jury charge for disorderly conduct is almost exact with the elements to the creating public disturbance 53A 181A. There's no obviously prepared jury charge for creating public disturbance, but the elements with regard to disorderly conduct and creating public disturbance, the subsection which the state is moving on here, are the same. So I'll be using essentially that analysis with regard to the elements that would have to be met, each one beyond reasonable doubt. I think I mentioned that to you in passing, but for the record, I'm going to make sure that you all understand this. With regard to the simple trespass, simple trespass really is a 2-element crime, and you can see it and go from there.
I just want to put one thing on the record because this is relevant to the defendant's motion for judgment of acquittal. Where Mr. Genussa orders the defendant to leave, I think 2 or 3 times in the stairwell. I know the court said did not come within an exception to the hearsay rule. The state had offered it.
You're offering it as a verbal act, that was it?
So I want the record to reflect the state was also offering the theory that it constitutes a verbal act.
So a verbal act, generally speaking, is a verbal statement which communicates a legal obligation to another individual. Attorney Seeger, Attorney Koopman. So that's essentially, they've rested, but essentially what they're asking me is to be able to consider when Mr. Reyes was asked to leave by Mr. Genussa.
Yes.
Mr. Genussa, as you know, anything he says can't be offered for the truth, based upon the fact that would be hearsay. What I think Attorney Zentner is doing is offering that particular statement, you have to leave, or something, an instruction to leave the building as a verbal act, communicating your legal obligation to Mr. Reyes. I'm not saying I will take it as such, but under circumstances, he has to be able to consider that statement as a verbal act. Is there any objection to that based upon your understanding of the laws of evidence as much as mine?
Mr. Koopman wants to address this, Your Honor.
Your Honor, I would say this. In order for it to be a verbal act, it has some legal authority, legal binding. There would have to be some foundation that the speaker had the authority to do so. There has been no evidence in this case that Mr. Genussa had the authority to do so. So that would be my objection, that there's no foundation for it to be used as a verbal act.
There's been a wealth of evidence introduced during the state's case in chief that Mr. Genussa was indeed the security guard hired by the City Hall to act in that capacity, from the town attorney, the town clerk as well. So that statement I was
kind of operating as the gatekeeper to the building, but I think Attorney Koopman's specific objection is he's not, a town employee potentially, maybe, he's certainly not an officer of the law, right? That's your essentially objection.
Part of it, Your Honor. There's been testimony of one that he is not an employee. He is hired by an outside company. He's responsive to that. There's evidence in the videos that he's routinely overruled by everyone in that building, the clerk and the lawyer. So there's no evidence that he has any authority to leave anyone. In fact, the witnesses who testified here, especially, I believe...
I understand your objection, and I understand the state's offer of proof. I will review my notes, make a ruling on that on Monday as well.
I would also add that the video itself shows on his sleeve, it says Allied Security, something to that effect, on Mr. Genussa's.
Well, I don't think Attorney Koopman is saying that he's not a security guard. I think he's saying that he's not There's no foundational testimony to establish that he has the right to tell anybody.
I would say,
I asked, your offer of proof to have that matter be considered by me as a verbal act is noted. Your objection there too is noted. Is there anyone would like to say about that before I then will rule on that on Monday?
Just that it cannot be said that I did not preserve the record, Your Honor. I would also go so far as to say there's even more so no evidence that he has the authority to eject anyone specifically from the clerk's office. In case it's a...
In case that's where I'm going to actually understood.
well, though it was the clerk herself, Ms. Gabler, who were defended out
Well,
multiple times.
that person testifies.
And she did testify.
So this is your specific request right now is to have the court consider the statements regarding demanding or instructing Mr. Reyes to be made by the security guard Phil Genussa. That is your offer of proof you're asking me.
In multiple places, the stairwell, the clerk's office.
I got it. You're saying that when he asks Mr. Reyes to leave, it is a verbal act, therefore not a hearsay statement, therefore admissible even though he did not testify. You're saying there's no foundational testimony to show that he had the authority to in fact let that authority to actually make him know, to render that duty upon him, to instruct him that he has that duty to go, right?
Yes, Your Honor.
Legal obligation to go. Got it. Any other evidentiary issues that you want to discuss at this time with regard to the information that's before this court and the motion limit? To be specific, motion limit has been granted to anything on those tapes that have been observed and listened to by the court to find their fact in this situation where they have not been subject to cross-examination here. Those are hearsay statements unless otherwise an exception to the hearsay. Attorney Zentner has made one.
I just want to... There is a part on the body cam of Officer Iacobellis at the 1837 one in the morning, where I think it's Sergeant Fernandez, Roy Fernandez, tells the defendant, the only thing you can't do is film within the department and disrupt the business. The defendant does not object or comment on that. I'm going to respectfully submit that that is an adoptive admission.
The silence as to him setting forth what he can and cannot do?
Yep. There's no objection or comment from the defendant. I'm going to argue that that's an adoptive admission by the defendant and it constitutes an exception to the hearsay.
Your Honor, my understanding...
And wait, who's the statement uttered by?
Officer Rui Fernandez.
Okay.
I have here in my notes, it's the 1837 one. So that's in the morning in the parking lot.
Your Honor, I would object to that because that is not what an adoptive admission is. An adoptive admission is when somebody is, say, silenced in the face of an accusation of the kind that one would respond. This is an instruction. So if somebody tells me, you can't come in with that shirt on, and I say nothing, doesn't mean that I agree that I can't come in with the shirt on, or that I will come in with the shirt on. That's not an adoptive admission.
Let me further submit that this too would also constitute a little act as well.
Again, Your Honor, the objection...
I say that in the alternative.
Got it. Your objection is the same with regard to the verbal act as it was for the verbal act offer of proof with regard to Mr. Genussa?
Well, same idea. There's no foundation that this... In fact, the evidence is it's a police officer who simply shows up and says that that's his view of the law. And quite frankly, if that's what the state wants to offer, I would take every other police officer's testimony, statements that he's not doing anything illegal, that what Mr. Ray is doing is fine, should be just as equally admissible for the same proposition. So, what's good for the goose is good for the other goose.
That's set in a completely different context.
I'll issue. I understand both offers approved. Does the defense have any offer approved to anything in the videos that they feel should be admissible, despite the motion of limit being granted? Actually, their motion.
Yes, Your Honor. There was a video played of, I believe, Sergeant Strabinci walking in to speak to the clerk. Prior to speaking with the clerk, he's looking for the clerk. There are members of town hall who make statements that to the effect that they're familiar with Mr. Reyes and are aware of his YouTube channel. It is not being offered for the truth of what it asserts. In other words, what they say is, oh, I saw the video that shows such and such. We don't care whether the court finds that they saw a specific video. Is they're familiar who he is, familiar with his work. It's knowledge on the part of agents of town hall, and it's relevant for the part of our argument that this is a policy being selectively enforced against our client for exercise of his First Amendment rights. Testimony at the trial has been there was a June 10th incident, followed by a one-day opposite of deep dive memo, which identifies him specifically. There's the
That's evidence.
And that video is the July 10th. The town is aware of who he is, aware of the content of his videos. This becomes now a content, at least our position is, as outlined in our memo.
Do you know who specifically makes the statements?
Their names are not available to us. It's not evident on the video. However, they make it in the presence of the police officers. They're clearly employees that have speaking capacity.
Saying it shows the state of mind of those individuals? How is it not here?
It's not their state of mind, Your Honor.
What are you trying to, what are you offering for this?
Knowledge of our client's work, and it's relevant specifically for finding a content-based restriction.
Two individuals that you don't know who they are and may or may not have anything to do with the crafting of the policy which you believe is being selectively enforced.
We do not know who they are. We know that they're town hall employees. They know they're in the city clerk's office. They're agents of the government, same way that police officers can be credited.
But the reason why you think it's relevant is because it shows that perhaps the people that generated the policy which you believe is being selectively enforced did so because specifically they knew Mr. Reyes in his pursuits.
Yes, Your Honor, it's supported by the memorandum. The memorandum refers to the specific.
About this memorandum?
Yes, Your Honor. No, I'm sorry, the memorandum which is in the exhibit. Yes,
Got
two memorandum.
Oh, the memorandum from the
attorney
Pinter.
From the
Attorney
corporate attorney Pinter, yes. That specifically refers to Long Island Audit, which is the YouTube channel.
Understood, but the person who makes the statement, is it Attorney Pinter?
No, Your Honor.
I will hold from ruling on it now, but that would be the court's concern on that. I understand the point of your objection, but I think that you are looking to have random statements made by individuals who may not have had any say or any kind of influence with regard to the generation of any kind of policy. I understand your point though, and it goes to your overriding defense of that this whole thing was selectively enforced upon one individual.
Yes, Your Honor.
Again, I'm going to object to the court considering it.
I would expect that. I think you would have an objection to anything the other side was on. Anything more?
No.
No, Your Honor.
Okay, look, we try to do the best we could to be as expeditious as possible. Sometimes when things take longer than we anticipated. Certainly, when I came up with this particular idea to try and have the video in, I thought it would streamline things. I don't know if it did. Certainly, if it did, I shudder to think what it would have been like if it hadn't been streamlined. But we are here now. I want to appreciate everybody's professionalism. You've all been zealous advocates. Mr. Reyes, you have been here, continuing to be patient as we tried to get to you. You see what it's not like, you know, there's nothing going on. We're trying always to get to your matter, and the way this has worked is I've used every moment of the day when I'm not doing the daily docket to do that. So I appreciate all of your assistance and the staff as well. So on Monday at 2, be here. We will start as soon as we possibly can. I will make rulings on what I have in front of me, and then we proceed to closing. Okay?
Thank you.
Thank you.
All right, we're not adjourned.